Right, welcome back everybody for the third in the series of bite-sized webinars discussing counterparty risk. Today's seminar is entitled Taking Back Control, Commercial Solutions Through Shiparrest, and will be given by members of our shipping team, namely Lewis Moore, who's a partner with us, and our senior associate, Rosie Goncare, and the legal director, Colin Lavelle. So you have three of them today. In terms of housekeeping, as with last week, and in order to keep the quality as clear as possible, we've muted all microphones, and I'd ask you if you could keep them muted, and could we also ask you to switch off your videos. During the course of the presentation, if anyone has any questions, please could they set them out in text using the text bubble function on the toolbar. And then at the end of the presentation, I'll raise the questions with the relevant speakers. Obviously, because well, you don't know this, but Colin's presentation will be given by a pre-recording as he's unable to join us today. So other than Colin, Lewis and Rosie will respond to the questions. Please also be aware that the text function will mean that everybody will be able to read your questions. So if you've got any good jokes, can you keep them clean, please? Of course, at the end of all this, if you have any other questions you would like to raise, if you would, please feel free to contact either Lewis, Rosie, or Colin direct, and they'll be happy to respond. Anyway, and now I shall hand over to Lewis. Thanks very much.
Thank you, Tony, for the introduction, and welcome everybody to this talk. As a little other housekeeping matter, I just let you know that the changing of the slides will be performed by Laura, our assistant, as in deference to perhaps the difficulties of the technical system for me as a partner in the firm. I'm going to talk about getting a commercial result and also about two cases involving ship arrests, where the primary purpose of the arrest was not to either secure a claim or to recover a debt, but to obtain other commercial benefits. Next slide, please. The first case involved an insolvency. In this case, the insolvent ship-owning company owned two vessels, and it was fortunate to own two vessels both free of mortgage, but unfortunately had several ships on long-term time charters at rates which were well above the market rate. One of the owned vessels was in the Far East, and the other one was in East Africa. Next slide, please. So the liquidator's problem was that he couldn't continue paying the rate on the time charters, but if he terminated the time charters, there would be a damages claim which would enable the vessel owners to arrest his two vessels and obtain security, which would be in advance of the general body of creditors. And of course, it's the liquidator's obligation to try and recover the company's money to pay a dividend to the creditors. Next slide, please. Now, you may say, well, if this is a liquidation matter, isn't it covered either by the European insolvency regulation or by the UNCITRAL cross-border insolvency regulations? And I will say that this case actually predated and perhaps even anticipated these two regulations. But the points I'm going to make are still relevant whether the regulations apply. And we should bear in mind that the European insolvency regulation may not be applicable to UK cases after the 1st of January 2021, depending on whether we really do crash out. And the UNCITRAL regulation only applies to 48 countries, not all of which are maritime nations, and one notable exception is Egypt. I think you can move on 2 slides, I think now. So the first ship in the Far East was actually in Taiwan, and nobody wanted that vessel to be dealt with under the Taiwanese jurisdiction. So the vessel was shifted to Hong Kong, and the liquidator issued a winding up petition in Hong Kong on the basis that he'd already opened a bank account which provided an asset in Hong Kong, and in Mombasa the other vessel had already arrived and the liquidator had an asset in that jurisdiction and therefore was also able to issue his winding up petition. Next slide, please. There were then contested winding up proceedings in both jurisdictions involving leading counsel from the Chancery Division of the High Courts in England, Hong Kong and Mombasa, and eventually the courts in both jurisdictions made winding up orders. Now, the relevance of this is, of course, that the winding up order dates back to the date that the petition was issued, and therefore, once the petition had been issued and the winding up order was made, it was impossible for the owners of the time-chartered vessels to bring proceedings in order to arrest the owned vessels to secure their claim. Next slide, please. So that disposed of phase one, in that the liquidator had recovered the assets and ring-fenced them from claims by other creditors outside the general body. But he then had two further problems. One was to actually dispose of the vessels at the best price he could achieve. And the second was to deal with the repatriation of the crew who had unpaid wages. And this is a very difficult issue. It's one that can create very high profile and all sorts of adverse publicity. And it was in the liquidator's very clear interest to ensure that the domestic crew were fully paid and got back to their home countries. So how was that achieved? Next slide, please. What the liquidator did was he approached a friendly shipping bank. In those days, that sort of entity actually existed. And through that bank, borrowed the funds to pay the crew's wages and to fund their return tickets back home. The crew's lien was then assigned to that bank. This requires a court order to ensure that the security of the lien is transferred. So the bank then had the benefit of the crew's priority claim. With the permission of the local liquidators, the bank then arrested the two vessels using the crew's lien claim as its lever, and the courts in the jurisdictions then sold the vessels as through the Admiralty Marshal, thereby achieving the best price that could be achieved and saving the liquidator from the difficulty of selling the vessels himself, where he would be unable to give any guarantees or warranties about claims, liens and encumbrances on the vessels. So through this proceedings, the liquidator actually achieved a recovery for the creditors of the company of the assets and avoided priority claims being brought by other ship owners who had charters with his company. So it was a successful result through international proceedings and brought back home to the liquidator the funds that he required. Next slide, please. I think that just summarizes what I've said, so if I could just move on one more. Thank you. My second case is actually a recorded decision. You'll find it in Lloyds, and it's about what I would call a white-collar piracy. The owning company of the vessel was owned 50-50 by two partners and was deadlocked. And as occasionally happens, the parties fell out and they could not decide how to continue the business. So they entered into a dissolution agreement under which a third-party lawyer was appointed to sell the vessel and distribute the proceeds between the two parties. Next slide, please. However, this didn't satisfy one of the parties, who decided to take the matters into his own hands, and on behalf of the owning company, he executed a bill of sale in favour of an ostensibly arm's-length company, and that company then on-sold the vessel 2 months later. The registration of the vessel was changed on the basis of the two bills of sales, so the owning company appeared to have lost the vessel. And there was a question as to whether or not these sales were genuine arm's length sales or they were shams. The vessel was in England, and so how was the owning company going to retrieve its asset? Next slide, please. The first problem was this deadlock. Until the authority was given by the third-party lawyer who was to sell the vessel, the company couldn't actually bring proceedings in its own name. It did not. There was no individual who had title to sue. But one of the partners did own some of the equipment on board the vessel. So in order to hold the fort for the time being, while the authority was obtained, a freezing order, a moravian injunction, was obtained in relation to the equipment on board the vessel, which then prevented the vessel from leaving the jurisdiction. And when the authority was given by the lawyer who had the ability to sell the vessel was arrested by the owning company. Next slide, please. As a result of this, there were two sets of proceedings in the English court. In rem, proceedings for a declaration that the title remained with the original owning company and that the UK registry was to be rectified to show the original owning company as still the owner. And there was the in personam claim for the delivery up of the equipment which was still on board the vessel. Next slide, please. So what happened was the court decided that the two sales were in fact shams and made the requested declaration that the title to the vessel remained with the owning company, and also gave a direction to the UK Registry of Ships to amend the registration details so that the original owning company was shown on the register as continuing to be the owning company. But there is an unfortunate postscript to this case, which actually does bring us back to an arrest. What had been scheduled for a 3-day trial turned into a joint venture dispute between the two parties and ran for 19 days. And the judgment is also a very lengthy judgment. And if you want to see how to go about trying to steal a ship as a white-collar criminal, there's a good summary in this case. But as a result of the length of the trial, the owning company became itself unable to meet the legal costs, which left the lawyers out of pocket. But that actually was an issue that could be addressed. Next slide, please. Under the Solicitors Act, a solicitor has a charge on his client's property, which he recovers through his efforts to secure his costs. And as a charge, that right falls within the Senior Courts Act 1981 and gives a right of arrest. And so in this case, the vessel was rearrested, this time by the lawyers, and sold by the court in order to pay the solicitor's costs with the balance of the sale proceeds. And I have to say that the solicitor's costs didn't use up all the sale proceeds, but the balance of the sale proceeds were then paid to the owning company. So that is a case where indeed the arrest of a ship was used for the specific purpose of recovering ownership of a vessel. And if it had not been for the costs issue, it would have been a totally successful outcome for the client. Now, ship recovery in this way is a topic which my colleague Rosie is now going to address in her talk. So thank you all very much for your attention. I hope there was something of interest there for you. And as Tony said at the beginning, if there are any questions, we'll be delighted to answer them for you. So over to you, Rosie. Thank you very much.
Thank you, Lewis. And good afternoon to you all. Thank you for joining us today. My name is Rosie Goncare. I'm a senior associate working in London office. I often deal with various arrest cases, and our aim is always to achieve a commercially sound result to our clients. Next slide, please. Today I will be talking about how to take back control of your own vessel. Hill Dickinson, next slide please. Hill Dickinson was recently instructed by the owners of a vessel who wanted to arrest their own vessel. Is that possible? And the answer is yes. So in our situation, the claim for possession was made by the bareboat owners under a bareboat charter hire purchase agreement due to the breach by bareboat charterers. Next slide, please. The law is clear, and the Section 20 of the Senior Courts Act 1981 says that the Admiralty Court has jurisdiction to hear and determine any of the questions and claims in relation to the possession or ownership of a ship or to the ownership of any share therein. Therefore, as you probably know, while applying for the arrest, the applying party has to specify exactly under which provision of the Senior Courts Act the claim is made. And in this situation, it was made under Section 22A of the Act, which allows the arrest. Next slide, please. Therefore, we filled all the necessary documents for our clients, and the vessel was successfully arrested when she arrived at one of the UK ports. After the vessel was arrested, we have had to deal with various practical and legal issues of the arrest. So first, the major issue was that at the time of the arrest, the vessel occupied a loading berth, where the fees, the port fees, were extremely large. Also, it was a very large vessel, and of course, you know that often the port dues are charged by gross tonnage. So therefore, the port fees were very fast accruing, and we were substantial, running into tens of thousands of pounds per day. Therefore, in the best interest of all parties, so the bareboat owners, the bareboat charterers, and also the port, who needed the berth, that particular berth, for other clients who were arriving in the next few days, the agreement was made for the vessel to be moved within the port. The port applied for an order, and the very same day, the Admiralty master issued a further order which permitted the vessel to be moved within the port, within a 5-mile radius. As a result, the vessel was moved to a less busy and the less expensive berth, and therefore we achieved about a 30% reduction of the port dues due to the move. Next slide, please. However, next slide, please. Thank you. However, the fees were still significant, and of course, the parties did not know how long the vessel would stay under the arrest and how long it will take for the parties to reach any sort of agreement. Therefore, we had to think about any other alternatives as to how to reduce the fast accruing fees. However, our client's main aim was, and as similar to the cases Lewis mentioned, not to obtain a payment of debt, but they were determined to get the vessel back from the bareboat charterers. Therefore, we came up with a plan, which we used on other cases as well, is to apply to the court for a permission to move a vessel outside the port to the anchorage. However, in that regard, there are certain risks to the arresting party, because it's very easy for the vessel to jump the arrest and simply pack up and go. Therefore, we were thinking about various possibilities as to how to, of course, secure our client's position. Initially, I was speaking to several of my colleague mariners and asking them if there is any possibility technically to disable the vessel, take the key vessel documents. Similar, I was thinking similar as to the car. Maybe we can take the keys. However, I was explained that that's of course not possible. As a next step, we were thinking about placing security guards on board. But yet again, that was an expensive option, and we did not know for how long security guards will be required. At the end, we actually came up with an option that where we required the crew of a vessel to surrender their passports and the seaman books to the UK authorities. That was agreed by the bareboat charterers, and therefore the passports and the other documents were surrendered to the border force authorities. Therefore, this ensured that most likely the crew will object any directions from the bareboat charters to leave and breach the arrest order. However, subsequently, we were thinking about various logistics as to how we move the vessel under arrest from the port to the anchorage. And also a very interesting thing happened that while the vessel proceeded under pilotage from the port to the anchorage, we received a report that the vessel's AIS tracking signal transmitter was not working. Therefore, it was impossible to monitor the vessel's movements. We have quickly phoned the charterers' agents and threatened that if the AIS is not fixed, we will order the vessel to be returned to the port. And quite funnily, that within minutes from our call, the AIS transmitters went back to working well. Further on, we were asking the port to monitor the vessel's movements as well with the help of a radar. But yet again, there was no real physical power to stop a vessel to move, to jump the arrest. A few weeks later, also, the vessel hit the adverse weather. And again, at that time, we had to consider whether, for the sake of safety of the vessel and the crew, the vessel was to return to the port, which later, fortunately, was not necessary. Next slide, please. After a few weeks being under the arrest, the parties were negotiating and reached a settlement agreement. And subsequently, we have applied for the release of the vessel from the arrest, and the consent order was issued by the court. During that time, there were also some issues in relation to service of the arrest documents, as charterers' lawyers challenged service, which is always affected by the Admiralty Court. Therefore, I also advised you to carefully check the documents submitted to the court and the opponents at the time and in the course of the arrest. Next slide, please. I think during this case, it was very, very important to have support of all parties, and in particular the support of the Admiralty Court, which assisted to both the bareboat owners and the charterers and also the port with very, very urgent, fast-changing circumstances. I remember once a question was asked by the audience during a ship arrested conference: can a vessel be arrested over the weekend in the UK? I think due to my recent experience on this matter, I can say that anything is possible, just because the Admiralty Court provides excellent service. And as you can see below, a brief timeline shows to you that we have been working under extreme, time pressure, and in the course of Christmas holidays and the New Year holidays, where often various people were, of course, on leave, or the courts were also shut. But as I said, due to extremely efficient assistance by the Admiralty Marshal, the deputies, masters, and the court clerks who assisted the parties to resolve the situation, this quick resolution of the dispute was possible. Next slide, please. And of course, the outcome of the case, the happy clients. So eventually, the bareboat owners, as they wished, took back control of their vessel. In fact, they placed their own crew on board of the vessel, and by this way, they took control of their own vessel. The port were also paid their harbour dues in full on departure from the port. And of course, the solicitors who were working day and night and out of hours and during holidays were also rewarded, and it was a very great experience as well. Thank you for listening. I hope you found it useful and interesting, and I will now pass the floor to my colleague Colin. Thank you. Goodbye.
Well, good afternoon. I'm Colin Lavelle, a legal director within the shipping team based in the Liverpool office, and I just thought I would share with you some of my experience in relation to commercial considerations for ship arrest. Some of the aspects that I've come across in cases and are worth considering with ship arrests are particular requirements of the Admiralty Marshal, the relevant priorities, and in the case I'm going to talk about shortly, particularly crew wages versus port costs, associated port cleanup costs following an arrest, challenging where necessary the established order of those priorities and parties' entitlements to the sale fund, relevant publicity, and also international considerations. So dealing with the case study, first of all, this was a case where a client of ours approached us because they owed significant sums in relation to port services, agency and bunkers. Now the debtor owned 5 vessels, but we were told that insolvency was imminent. Accordingly, prompt action was required to avoid any security being prevented, and we prepared and sent letters before action in relation to the debt and arrested all 5 vessels in various ports. This resulted in long-running negotiations with the owner and the release of 3 vessels in return for part payment of the debt, along with ultimately sale by the Admiralty Marshal of the 2 remaining vessels. One of the complications here was that given the length of time the vessels had been under arrest, there were also substantial crew and port claims to be addressed from the sale proceeds, which caused a conflict in the priorities. Accordingly, the Admiralty Marshal was unwilling to provide an order for sale or to support an order for sale unless of either vessel, unless the Admiralty Marshal was satisfied that the ports and crew claims would be satisfied so that they would not exercise a lien following the sale. Now the dilemma here was the port had a higher priority and the crew wouldn't leave unless they had been paid in full, and we were concerned that the sale proceeds of both vessels would not satisfy both of those claims. Now, the priorities in this sort of situation are, first of all, the Admiralty Marshal's expenses, then the arrest costs, then the port dues and costs, and then the crew wages. And in addition, there were also port cleanup costs where the ports would need to require the berths servicing the vessels to be dredged, which meant that out of a limited fund, there may be some issues. Now, this meant that a commercial approach was needed, which resulted in us discussing the position with the ports and the crew's representatives on a without prejudice basis, and proposing that an agreement be put in place that the crew claim would actually take priority to the port claim. The theory to that being that once in place, our client would pay the crew wages and repatriation costs. The crew would then leave the vessel. The Admiralty Marshal, once that agreement was in place, would allow the vessels to be sold, and the crew's claim would be subrogated in favour of our client. Unfortunately, one fly in the ointment here was that one of the vessels was on a private wharf, and that wharf owner was unwilling to allow the crew wages claim to take priority to its claim. However, the Admiralty Marshal was nevertheless satisfied that we had reached agreement with the crew and agreed to allow the sale of the 2 vessels, with any sale proceeds to be paid into court, which then followed subsequently. As predicted, the sale fund was limited, and accordingly, the wharf owner challenged the payment out to our client in relation to the subrogated crew claim on the basis that it had a higher priority. This meant that a number of considerations has to be borne in mind by the court, including, had there been a prompt request for the Admiralty Marshal to either require the arrested vessel to be moved off the berth and moved to an alternative anchorage, or that the Admiralty Marshal pay the relevant fees. This meant that there should have been a timely and proactive invoicing arrangement with the Admiralty Marshal from the date of arrest. Unfortunately, in this case, for the wharf owner, they had not been sending the invoices to the Admiralty Marshal, but instead had been sending them to our client. It also needs to be considered whether there was the availability of an alternative or cheaper berth, which there was, and whether there'd been any application by the wharf owners to move the vessel so that it could reduce those costs, and whether the costs incurred had been reasonable. In this case, it seemed that as soon as the vessel had been arrested, the wharf owner had increased its charges. And in addition, whether VAT had been charged. Here, the wharf owner had also charged VAT on top, despite the fact that VAT is not chargeable on berthing vessels for qualifying, on berthing fees for qualifying vessels. But the wharf owner argued that it was operating the wharf within a harbour authority where the harbour operator had been liaising with the Admiralty Marshal directly. However, we successfully argued that the wharf is not a port and therefore didn't have the power of detention and sale of a vessel under Section 44 of the Harbour Docks and Piers Clauses Act, and therefore was not able to claim that it had a priority to the crew wages at all. Luckily, the court agreed with our interpretation and accordingly struck out the wharf's claim, and given their obstruction to the initial attempts to try to resolve the matter, ordered the wharf to pay our costs as well. Now, another factor to consider is the media pressure that can occur in a situation like this. As I mentioned, these vessels had been under arrest for some time and so had generated some significant local press interest and some national interest. Now, this creates a focus on the vulnerability of seafarers, which is a great story for the press to publish, and also is, to be fair, is a relevant story. But it also creates the belief that the crew wages will be unpaid. Now, this can happen, but it isn't always the case. And it means that interested parties are then under pressure to provide regular updates either to the press or to the court or to the various parties on the status of the arrested vessels. Together, this can cause disputes to become harder to settle, and so actually increasing the time that the crew are stranded. And as well as that, it obviously can create some negative publicity for the port, the ship's owners, and the claimant. And here are just a few examples of some of the headlines that it reached both in the local and national press, including an article or a feature on the One Show, including terms such as Admiralty Marshal leaving the crew destitute, which obviously is not correct. Admiralty Marshal has a duty to look after the crew as soon as the vessels are under arrest, and that references to the crew being treated as slaves, etc., etc. So what lessons can be learned from an example like this? Well, it's important to explore the commercial options at an early stage to maximise recovery. This will also, in the long term, help to minimise the expenses associated with enforcement. And where necessary, it's good to cooperate with the maritime lien holders, and in this case, the crew in the port, where their agreement to paying off the crew early and giving them a priority was essential for the sale of both vessels. Parties should also be aware of the media coverage that arrests often generate and the reputational and brand issues that this can affect. And where necessary, consider challenging claims under the established priorities, especially where the sale fund is limited. So I hope that's been a useful insight into some of the commercial considerations. Although I'm not here in person to answer your questions today, I'd be delighted to respond to any questions you might have by email, or alternatively later on Lewis and Rosie might be able to deal with those for you. But in the meantime, thank you very much for listening.
Well, thank you to Lewis, Rosie and Colin. I hope you found that interesting. I don't have any questions here now, so I think it's really just it's the time to say thank you for joining us this week, and I hope you can join us next week at the same time for the 4th presentation in the series, which we hope to be on freezing orders. Anyway, look forward to seeing you all next week, and thank you very much. Bye.
Thank you.